right, so I've been seeing so many videos online where people says that you could actually apply for a skilled worker visa extension without certificate of sponsorship, and that particular information did not just go down well with me. So I feel like, okay, we need to talk about this and then see how possible it is, if it's a valid information or not. And in determining this, we will be using the information that the government themselves have put on their website. And this was published on the 22nd of July 2025. As you can see on the screen, this is skilled worker caseworker guideline. This is the exact document that caseworkers uses to assess your application. This says if your application is going to be refused or granted. So we'll scroll down to the part that says sponsorship. This section explains how to assess the sponsorship requirement for skilled workers. The applicant must score 20 points for sponsorship. To award this point, you must be satisfied the application meets the requirement in paragraph SW 5.1 to SW 5.7. Valid certificate of sponsorship. Valid certificate of sponsorship. A certificate of sponsorship is only valid if certain requirements are met. The CoS assigned to the applicant must meet all the requirements set out in paragraph SW 5.1. You should contact the sponsor to request any missing details. In particular, the employer pay as you earn reference number the applicant will be assigned to may be missing if CoS was assigned before the launch of the skilled worker route. If the application is for entry clearance, that's if the person is coming in from outside of the United Kingdom, the CoS must be defined CoS. This means the sponsor has requested it for the specific job and salary shown and has not assigned it from their general allocation. The sponsor must hold a valid skilled worker sponsor license. The sponsor must also be A-rated, or else the applicant is applying for an extension to continue working for the same sponsor. You must confirm these requirements are met by accessing the certificate of sponsorship checking system. You can contact the sponsor licensing unit, that's SLU, to find out more information about the status of a sponsor's license if needed. If the applicant sponsor loses its license while the application is under consideration, you have a duty to inform the applicant promptly. You must only inform the applicant their sponsor no longer have a license, not the reason why. The only exemption is if this license was revoked for reasons directly linked to this application, and those reasons therefore have particular relevance to the refuser. For example, you are refusing on a genuine vacancy grounds, as well as the fact the sponsor is no longer licensed. Listen to this particular part. As you can see on the screen, certificate of sponsorship. The applicant must have a certificate of sponsorship. This is a visual document similar to a database record which is assigned by the sponsor. Sponsor use a secure IT system called Sponsorship Management System, SMS, to assign a CoS. The reference number for the certificate of sponsorship should be provided in the application. If the applicant has not supplied the reference number, they must underline that word, they must provide an explanation. If you are not satisfied the sponsor has assigned a CoS to the applicant, you must reject the application. In another words, you must refuse the application. If the reason the sponsor has not yet assigned a CoS is because of delays by UKVI, for example, a delay in processing a sponsor license application or a request for a CoS, you may exceptionally place the case on hold pending the outcome. So guys, how do you understand this particular information? I mean this last one. You know, many people have been on saying that you could actually apply for CoS. All you have to do is just for you to contact an immigration lawyer. And I know very well that there is no immigration lawyer that would even encourage you to submit an application to extend your visa without a CoS, except, underline it, except if the delays were caused by the Home Office. It's very difficult before you can see or experience a delay. Probably they are trying to verify something or are delaying the process of assigning the CoS, because now it's not even your application they are talking about. Let me just give us a very common example of this. It could be that you have been working for this company. Probably they gave you like 2 years COS. And then the truth remains that most of these companies, they will tell you that they will have to wait. Probably while waiting, your visa is about running out. And this company decides to wait until the last minute before applying for the COS from the home office. Maybe your visa is expiring like in 2 days and they are just applying for the COS now. Only in that case, which is very rare, it's only in that case that you could actually go on to submit your application without a COS. However, you must attach an explanation letter. You heard it when I read it out, that there must be an explanation for that. If not, outright is outright refusal. They will just refuse it. So the common cases, like I said, is when your employers are trying to get in touch with the home office regarding the allocation of your COS, and they are unable to achieve this before your visa runs out. And because you need to submit an application, you just have to do that without the COS. Do not forget that they cannot still process your application without a valid COS. So all they will do, according to that information, is to place that application on hold. They will have to place the application on hold pending when they are able to, reassign the COS to your employer. And then your employer sends the COS to you. And probably you send it to the home office. However you want to do it, the home office must receive a copy of your COS before they can grant your skilled worker visa extension. So they did not waive that part too. Let's just understand this. Only thing is that it gives you time. When your visa expires and you are not able to submit any application, it means that you're already an overstayer. So the only thing that I see there is that it gives you time. So instead of you becoming an overstayer, you are still in the United Kingdom legally until that visa is granted. So guys, let's not twist it. I just thought of it because I've been going online and I've been seeing people coming out, on TikTok telling you that you can actually apply for a visa extension without a certificate of sponsorship. Yes, that's correct. You could actually do that, but do not forget that that visa cannot be granted without a certificate of sponsorship. So there must be a reason, even in the first place, there must be a reason why you are doing that. It must be that the home office, due to whatsoever delay, was unable to assign that COS to your employer or to allocate the COS. That reason must be associated to, to the home office. So I believe this information is clear. Please, if you have not liked this video and you have watched up to this moment, kindly do that now. Thank you again for watching, and I remain blessing a muzzle of Blessed Blessing channel. Thank you. Bye-bye.